Well, if you're just joining us, we continue to follow breaking news from Washington as the Supreme Court overturns Roe v. Wade.
Let's take you through what this means here in Michigan. Today's decision by the court now gives state legislatures the power to settle abortion rights laws. Here in Michigan, a 1931 law banning abortion would go in place, but that law has been blocked, at least for now. So as it stands, abortion is legal here in Michigan.
We want to get to some insight into not only the court's decision, but also the wide-reaching impact that it will have. And for that, we want to bring in former U.S. Attorney and current U of M law professor Barbara McQuade. Barb, thanks so much for joining us. Good to see you.
Thanks, Kimberly. Glad to be with you.
Absolutely. So Jason just mentioned that 1931 law banning abortion that would go into place. But back in April, we know Governor Whitmer filed a lawsuit against that ban. It's blocked for now. Can it stay that way, or what could happen with that?
Yes, so the judge in that case entered what's known as a preliminary injunction, and that is an indication that she thinks there's a substantial likelihood of success on the merits of blocking that permanently, but it was just a preliminary decision. It was done quickly because people knew that this Dobbs case was out there and was going to be decided soon, and the purpose of the lawsuit was to avoid having the case thrown into just chaos when that decision came down, like today, so that there could be time to have a thoughtful approach to decide whether that case, that 1931 law is valid or not. So that case will play out in the coming months. The court will make a final decision. I imagine it will be appealed to the Michigan Supreme Court. So it could be well into next year, to 2023, before we get a final decision on that. For now, abortion remains the law in Michigan.
Yeah. A lot of states, no doubt, will be watching Michigan to see how we handle this decision. And what happens could have a ripple effect, not just in Michigan, but across the country and on upcoming elections. What are your thoughts on that and what happens from here?
Well, I think you're right, Kimberly, about elections. And I think it's going to be true in many states. You know, there's about a dozen states that had trigger laws that have gone into effect immediately today, making abortion illegal in their states. Another 25 that had these old laws on the books that are kind of in this legal limbo right now. And then other states that are deciding what to do. The Supreme Court kind of gives them a blank slate to decide whether they want to make abortion permissible, as it is protected in some states, or to ban it. And I imagine this is going to become a very hot button issue for us here in Michigan in November. There is a petition that's being circulated right now for a ballot proposal to amend our Michigan Constitution to make it clear that the right to an abortion is a protected right under our Michigan Constitution. So if that gets on the ballot, I think that could really bring out a lot of voters on both sides of that issue this fall.
Yeah. Back to that 1931 law, Attorney General Dana Nessel has said she will not enforce that law. County prosecutors, some, have said the same. But what about the ones that don't agree? What does that mean for women's reproductive rights?
Yeah, so we could find ourselves in a very odd situation. The Attorney General isn't enforcing it, but in Michigan, each county prosecutor is an elected official who has the ability to enforce laws that arise within his or her jurisdiction. So we could have the very curious situation that in, say, Wayne County or Oakland County, where the prosecutors have said they're not going to enforce the ban, people can obtain abortions. But in other counties, like Macomb County, where the prosecutor said he will enforce the ban, it's illegal. It would be a very curious situation. And I think that having these laws on the books will chill doctors and other healthcare providers from performing abortions no matter where they are. So I think that legal uncertainty is just not good for anybody. And so I think having put it to the voters in November for a constitutional amendment might be the best way to get clarity, because that's what people really need to be able to operate in this environment.
Sure. Barb, we got about a minute left. A lot of people may be wondering, could other decisions be overturned? You know about that concurring opinion that Justice Clarence Thomas called on the Supreme Court, and he just pretty much came out and said to build on overturning Roe versus Wade by reassessing rights to same-sex marriage as well as contraception. What are your thoughts on that?
I think all of those things are now fair game, and that's because the foundation on which this abortion right rested is the same foundation for all of those. It's called the substantive due process right. In 1973, the court read into the Constitution a privacy right as an unenumerated right that wasn't articulated in the Constitution but is reserved to the people. If that idea of substantive due process goes away, that is the same basis for those cases you just mentioned, like contraception and same-sex marriage and interracial marriage. And so it won't be tomorrow, because you have to have a case or controversy come before the court. But if a state wanted to ban, say, same-sex marriage, and then have that appear before the court, I think there's nothing to prevent the court from doing what it did today and reversing the Obergefell decision to ban or at least remove the protections for same-sex marriage.
Barb McQuade, we thank you so much for joining us, and we appreciate your insight and perspective.
Thank you, Kim.